audience, hello, I'm Chuck Dick. I am one of the co-chairs of the programming committee for California arbitration, and I have the privilege of serving today as a host for a very interesting interview as a part of our California Conversations series. I'm particularly delighted today to have the privilege of interviewing a longtime professional colleague and friend, and the first of our interviews that we've done with someone here actually in San Diego, my hometown. So it's a double pleasure to have with us today David Brennan. David is on the faculty at the University of San Diego School of Law and has a most interesting background and a great story to tell, I think, that will be of interest to our viewing public. So David, welcome to California Conversations. I'm really looking forward to this interview today.
I am.
So you and I first met many decades ago when you were what I would call a classic insurance defense lawyer. I seem to recall you had some prominence in the International Association of Insurance Defense Counsel, which ultimately became International Association of Defense Counsel. You had a practice that covered most of Southern California, and maybe you can tell us how you got from that classic civil litigation background into the field of alternative dispute resolution and more specifically arbitration.
Well, the firm I started with was a consummate try every case. And so I very quickly got involved in litigation. In my first half year, I tried 5 jury trials in Superior Court. The first one was 2 weeks after I joined the firm. So it was a succession of doing many trials in locations, first in San Francisco, then their Sacramento office, and then in order to become a partner, you had to open up another office. So I was designated to open up the Orange County office. And I did. I moved down and opened the office, and it grew quite rapidly. And then about 18 months later, I decided that I would form my own firm. So we came to a parting of ways. It was mostly amicable. And then I built the firm. I had Brennan and Hollins in Orange County for a number of years and got to the point where I had 24 lawyers and a lot of administrative stuff. And I was still trying the same number of lawsuits. And I got kind of sort of a burnout that how many more can I do these? I used to say, you only have so many shots of adrenaline. So what are you going to do? So what I did is I actually bought my partners out of that firm because I was a major shareholder, downsized, and I was in San Diego then because my bride was from San Diego, and it was much more convenient to be down here. So I worked with that firm I started down here for a while. I was up in La Jolla, but I started getting assignments to be a temporary judge, a mediator when the pilot project came out. And so I started doing private mediations and the ones assigned by the court, and I found them very interesting. I finally decided that I had to take a sabbatical. So I did. So from 1990 to 1992, I took my 40-foot sailboat and went sailing in the Sea of Cortez, and then working in Mayan archaeology in Belize, Guatemala, another one of my avocations. When I came back to doing legal work, I only lined up with firms that would let me manage the case. We'd make an arrangement on what it was going to cost and what the sharing would be. And so I took large cases. in that particular context and work them through. But I was still doing my mediation on the side and occasional arbitrations and settlement conferences, both in Orange County and Vista, California.
You said
So,
you described your experience in mediation and arbitration as, quote, interesting. You found that interesting. I'd like you to expand on that a little bit. What was it that, differing from your satisfying civil litigation experience, brought you a kind of fulfillment that was appealing?
I found it interesting and actually rewarding because I could be a facilitator even if people would come in for a quote unquote mediation. Well, I will not sit in the room with that particular party. We will have no conversations. We're going to make no offers. So this is a waste of time. And my usual comment was, great, we've got a wonderful start. Now let's go sit down in the room and have a conversation about this. And I realized that that style tends to push down the animus that people have. And I was pretty successful in settling cases. Some of the cases I actually was doing the mediation, and then the parties would say, well, we want an award or a judgment or something like that, and would ask me if I would arbitrate the case. Yes, with all the disclosures that I'm going to hear from both sides and make an award. And I did a few of those, which were also very rewarding. But I got a good feel for all of that working up until 911. And 911 was, for me, the worst thing that I had seen in my lifetime. And I looked at my wife and I said, you know what? This is going to be the biggest blowout in international law that you have ever seen. I'm going to go get an LLM in international law. And I had actually done a very large international arbitration case before then. And so I had a moxie on what it was. So I came back, got an LLM, and almost immediately USD found a job for me working at Western State College of Law to set up their international program. So I did. And of course, core courses I taught involved CICIG, international arbitration, mediation, and war crimes, which I had an interest in.
This was back at Western State in Orange County.
Right. So I burned through 2 cars because I was commuting back and forth 4 days a week. So after 5 years, I came back down to USC and talked to Dean Cole and say, couldn't you hire me for a job here? Because I've created all these courses up there and I can fit in down here. So he immediately hired me, and 2010 is when I started here. And the focus here became on training a student organization that was engaged extensively in international arbitration competitions. So I took all of what I had studied and learned, and I said, I'll become your coach advisor. And it's a very strong program.
David, you're one of the most thoughtful people I know in this broad field of dispute resolution. And I can't help wondering whether a couple of years on a sailboat down in the Sea of Cortez didn't open your eyes and after some introspection, give you some insights into yourself that may explain why you have found such a natural home as a thought leader in our profession. Share some of that with us, would you?
Well, that was a peaceful experience, and it was something that I always wanted to do. And I parked my boat down in La Paz and would go down and sail around and then come back and go back and forth. But after doing that, I had the feeling that I didn't want to operate a large law firm again. I just didn't want to do it. And so that's why I went into this kind of contract business or small firm situation, because running a law firm was really a grudge.
You have earned quite a reputation in the academic world here of recent date with your work at the University of San Diego. But I wonder, what are some of the things you learned in your years up at Western State? That's a 5-year span that must have been full of lessons to be learned and to how to improve your capacity as a teacher, but about the whole subject as well. Could you amplify a little bit on that period of time?
Sure. What I learned there, of course, I came there and they had no international law courses whatsoever. And some of the faculty were a little bit pushback. They didn't see why we needed to have a war crimes course or an arbitration course or things like that. They were just not focused on that. So I had to do a little convincing, but the dean and the vice dean I had there said, it's open to you. We want you to create these particular situations. And in that context, I got involved in the competitions that were there, and they had 11 competitions, and I became the director of those competitions, meaning I was taking some of the teams to different competitions and learning more about working with students. And I was fascinated working with them. I looked at those students then, and I look at them today, say, these are some real bright kids, and they can do great stuff, but you've got to bring it out. You got to give them motivation. Why should I do this competition? What's it going to mean to me later? And why should I study arbitration or mediation or any of this stuff? Because you've heard it, Chuck, before. I'm going to be a trial lawyer. And my answer was, oh, I think you're going to be disappointed. It's certainly by the time I was teaching.
When you got to back to San Diego at the USD, uh, did you inherit an existing program, or were you charged with starting from scratch there as well?
No, uh, I inherited a program that had been going on for about 5 years, and it was called VCAM, and it was related to the Viz International Competition, which is held annually in Hong Kong and Vienna. Vienna is the biggie. And it was a good student organization. And Mike Thorsness, had a lot to do with USD. And he found out that I was going to teach a course in international arbitration, grabbed me and said, wait a minute, you got to come help us. We could really use this course. So I went there and I actually designed a course for that organization based on the particular competition, and then became the coach advisor from that point forward.
Well, you've gotten quite a reputation in this field, particularly with the teams that you've taken to the Viz Moot competitions. And I wonder if you could share some of those experiences for us.
Yes, I really like the organization to make decisions. As a matter of fact, I interface with the president or the vice president or any of the other people, and they will come to me with problems, and I say, "This is great, but I'm only a coach advisor. I want you to learn to make the decisions." And the same held true for the decisions on creating the briefs, the decision on the practices, the decisions on selecting who's going to go where in what competition. And I could give them some advice, but I always like them to make the decision ultimately, because I said, it's your program and it's your competition, and you're the ones who are going to be doing the real work. And it's been pretty effective.
Are these students who come to you saying, Professor Brennan, we want to be international arbitrators, or do they just find this to be an interesting extracurricular activity?
No, we have a lot of candidates for the program every year, and they only take 5 or 6 candidates because you know, there's 2 major competitions, and it just can't grow that big. It would become unmanageable. So we do tryouts with 1Ls who try out for it. I think our last tryout is we had 28 and we selected 6, which was a big number. And then the 1Ls who are selected really don't do anything for the first year, but when they become a 2L, then they get into all of the facets of the competition. And you know, the reality is the competition runs from October through April of each year. But I teach my course for those students, so it ends and it covers both international arbitration and the Convention on International Sales of Goods in 8.5 weeks. And it is a proactive course. It isn't me lecturing, it's they are walking through a mock problem at every step of the way. Petition for arbitration, selection of arbitrators, challenge to the arbitrator, early meeting, experts, cross-examination, and open and closing statements. They do that all in 8 weeks involving those 2 subjects.
Have you seen some of your students after they have been graduated from law school decide to pursue this as a career specifically?
Oh, yes. Oh, yes.
Tell me about that.
Charlene Tung was a graduate just before I came. Charlene Tung is in a major firm in Hong Kong, and she also is one of the directors of the competitions at this day and runs what's called the Moot organization of all these students all over the globe who have competed in this, who now are members of that organization. That's one. Then I have Sam Song, who is with Fresh Fields in Dubai, who was the #1 orator in the 2014 Vienna competition among 970 orators. And I have a more recent graduate who then got into a Georgetown LLM in arbitration, and she's now a deputy counsel at the ICC in New York City. But I have others who are working in situations like that. But yeah, they go out and do it. My comment is, after they go through the 8-week course and this studying, the problem that comes out is 65 pages long with facts, documents, witness statements, experts, everything. And they go through all of this. I said, after this, you could go to a law firm in San Diego or anywhere, and if somebody came in and said, oh my gosh, we just got a notice of an international arbitration, what do we do? That student could say, give it to me, I'll show you exactly what we're going to do, and go forward with it.
Well, you're teaching more than just how do I draft a demand for arbitration, for example. You're teaching some values that I know from our other conversations, you believe carry your students forward well in whatever they choose to do in the practice of law. Share with our audience here a little bit today, David. What are the things that you're really trying to impart to them that would make a difference in their career?
One primary thing is civility. You and I, having been in litigation for 50 years, understand that there's a lot of incivility that goes on between lawyers. It is totally unnecessary. Each of my students get a little disc that they have to put on their keychain that says civility counts. And everything I do focuses on that, how you interact with a tribunal, how you interact with the opponent, how you interact with the parties, how you cross-examine witnesses, how you cross-examine experts, how you treat this process as one that has to be conducted civilly. And it isn't about winning at all costs.
Are there other lessons that you try to inculcate?
To have confidence in themselves. In other words, what they learn in law school, not just my course, but all courses, should give them the confidence that they can go out and really do good things in the legal field and be a good practitioner, whether they're going to be, want to be an arbitrator, or they want to go into criminal law as representing criminals, whatever they're doing, they're focusing on putting forth the best that they can do in that particular situation. One of my long paths that gives me that push is that when I was in the Navy and I was in the criminal justice system, some of the JAG lawyers were just not willing to really represent a client or advocate their particular cases. And they were more interested in just pleading them out where there were a lot of holes in the cases. And it used to disgust me that, here you're a young person, you committed a crime in the Navy, you go to a JAG lawyer and not interested in the time. And this was during the Vietnam era.
If you have a student come up to you today saying, I'm interested in this concept of arbitration generally and more specifically international arbitration, what advice would you give to those people?
Well, the first advice I would give them is look online and see what you find out about international arbitration. Number one, I would give them a book. I would give them a text and say, take a read of this. Margaret Moses has an excellent work that I use as a textbook, and say, read this and think about this. But then you also have to consider taking courses in international trade, international business transactions, and things like that. Because if you want to do international cases, you've got to understand how that works, starting from the UN, starting with all of the things that come from UNCITRAL about international arbitration, and how does international trade work? Why does it work? Primary purpose of it was to avoid nations going into war again and having a mechanism that they were interdependent on each other for goods and services and financial things, so that wars weren't necessary. And if there were disputes, right out of the UN Charter, there is an obligation on states and parties to avoid hostilities and treat any kind of dispute as one that should be peacefully resolved. It's right out of Article 2, Section 2.
I have a clear-cut interest in the resolution of international conflict. And where does that all come from? And tell us a little bit more about where it is taking you here. You talked about Margaret Moses's book. You have a book in the works, and maybe you can share a little bit of that story for us.
Because I from childhood, I knew about World War I or World War II, and my father gave me some books about it. And so I studied it all along. When we got to the time of the Balkan Wars, Serbia, and those tribunals began. I went and actually observed some of the trials. And I also reserved the International Court of Justice first 2 weeks proceeding with Serbia or against Serbia, Bosnia Herzegovina versus Serbia Montenegro for genocide, because I have an interest in genocide too. And I watched the first 2 weeks of that. I also watched 2 of the different ICTY trials that involve war criminals. The last one I watched was Karadzic. And Karadzic is a name well known in that particular spheres because he was the governor general of that particular region. And he and Mladic did just unbelievable things in terms of genocide. So that is a kind of a focus.
Well, you are working on a book that I think starts with your observations about World War I and carries forward. And tell us a little bit about the work that you're currently involved in.
My wife had some dear friends that she met on a trip to Europe after college from Belgium. And she stayed in touch with them. And in 1992, we went to Belgium to visit them. And they lived in Ypres. And as you know, Ypres in World War I was an epicenter of the war. The line from north-south went through Ypres. And Ypres was reduced to a complete rubble. So the family had the experience I learned from the mother of Luisa's friends, had been occupied in their house by German officers. But their earlier family, the father, I guess it was the grandfather, had kept track of all the houses in Ypres so people could come back and claim that because it was just rubble. And he became a significant figure. At the end of World War I, at Menin Gate, there's a huge gate that has the names of all of the unknown soldiers, and it's got tens of thousands on there. Ypres decided that they wanted to do a commemoration of the war and the end of it. So they have a ceremony that goes on every night at Menin Gate and has gone on for decades. And one of our friends we're going to be seeing just in 3 weeks ran that particular organization. And so they would have a ceremony, marching band, and oftentimes veterans of that particular era in 1992, very elderly, who were coming back to commemorate that. And that, I mean, it really impressed me. But then I also looked at some of the battlefields. And in and around Ypres, they are unbelievable to realize that 500,000 casualties at this particular place. It's just hard to fathom. And none of it was necessary.
How could it have been avoided? How could that have been avoided?
It could have been avoided because Austria-Hungary was particularly interested in taking care of Serbia because of the assassination of Franz Ferdinand, the Archduke, in Sarajevo, which occurred, I'm trying to think, it was May or June of 2014. So what they did is they served a set of demands on Serbia because they held Serbia liable because the assassin was a 22-year-old dissident who failed all the tests in shooting until he got to Franz Ferdinand, and he had both Franz Ferdinand and his wife. So they made these demands, and Serbia sent back the demands where they agreed to everything but part of one. And so Kaiser Wilhelm, who was really overseeing a lot of this, looked at it and he said, "This is wonderful. I can mediate this, and there'll be no necessity for Austria to attack Serbia." And that was July 26th. And by July 30th, the war started. And it started because the German general staff were so pumped up with what was called the Schlieffen Plan. And the Schlieffen Plan was the plan for Germany to go out and defeat France and then later defeat Russia, because they felt that they were hemmed in by them. So the Kaiser went to an 11-hour meeting with the German general staff and all of the politicos who wanted to go to the war. The next day he went and announced that we were going to war, and his quip was, "The boys will be home before the leaves fall." This was in July. Well, he missed it by about 52 months. Could have stopped right there. And Britain was desperately, Sir Edward Grey was trying to go with negotiations with all the parties, but the hotheads pushed it back. They wanted the war. And the true fact is, if you really study World War I, it lasted for Germany on a good basis for about 6 weeks. And then it stopped because they couldn't go any further, and they would never, ever again be able to get that many troops lined up to defeat France. So you just entered into these lines. And what is terrible about the lines of World War I, if we are looking at the war in Ukraine today, the trenches and the conditions and the type of warfare, it's pretty close to World War I.
So how does this give rise to the book that you're writing?
To give what?
Give rise to the book that you are writing.
I'm trying to analyze it in a way that I can say, look at all the steps that you could have done other than mobilizing troops or bombing something or doing whatever you're doing. Look at all the opportunities you have to resolve these particular situations. You could take them.
You started into this work as a neutral in the ADR work, both as an arbitrator and as a mediator.
Mm-hmm.
Are you still doing that kind of work?
No. Once I got down to USD, my contract required me to work 40 hours a week. So it just wouldn't fly. So essentially, and it doesn't bother me. I'd love to do some, but I'm so focused on how many of these students I can train who are going to go out there and who are going to do something big in this context at a future time. It's very rewarding.
You are a professor of practice. What does that mean?
The practice of international arbitration. In other words, we have professors of practice like in tax, torts, things like that. We are not tenured faculty, so we have no obligation to write and publish and things like that. But we're here for a specific purpose.
You described this course, though, as I understand it, really lasting a matter of a few months. What does the balance of the year look like for David Brennan?
Oh, the balance of the year after the course?
Yes.
We immediately gather around to figure out how we are going to create 4 briefs to answer for the claimant and the respondent in the two different jurisdictions that we're going to be competing. And that brief starts, the creation of it starts about October, and the first brief has to be filed by December 6th, the second one later in January. As soon as that stops, and you should see the number of things going back and forth. The briefs end up being about 60 to 80 pages long, annotated, obviously, with the international law and what's
You
applicable.
you put USD and its School of Law on the proverbial map when it comes to discussions about the Moot competitions
Right.
in Asia and in Austria. I suspect that's been a source of some pride for you, but tell me a little bit more about what are the most fulfilling aspects of having seen this program under your direction arrive at that level of stature?
Uh, well, there's a couple. Now, first of all, I will tell you the vast majority of my students pass the bar the first time. And the school always asks me why. And I say, because what I run them through is like a bar examination. They're doing answers to what would be bar questions, complex questions. And they also know how to prepare for it and really prepare. In other words, you can't leave loose ends. We always talk about, when we're talking about the competition, that in order to win, you have to give up the fear of losing. And you have to have the confidence that you can answer any question that is going to be posed to you in this particular competition, regardless of what the arbitrator might think about your answer. But you've got to be there to do this.
What are your observations about the future of international arbitration generally and specifically here in California?
Generally, internationally, it's growing. It definitely is growing. And the more countries, particularly now Africa and other countries that have not been involved, are getting involved. Number one, the viz is kind of an elixir for them. Everybody wants to go to the viz. When you go to the viz competition now, you've got 3,000 students who are going to compete over several days. Hong Kong has increased its, and there are a number of moots all over the place. And USD, we have our own moot competition down here, and students come from foreign countries to participate in it. So, and we're the only one on the West Coast. There just aren't many around.
You see some observations about the future of this practice in California.
Yes, I would hope, and I would hope that now that we've relaxed the situation, that arbitrators or that counsel from foreign countries can represent somebody in California in arbitration, and the arbitration rules are loosening, I think it can grow, particularly the advent of CalArb is a focus of a lot of people, great membership, and I think it serves to do that. The idea that JAMS and AAA is doing everything they can to facilitate any kind of international arbitration. I mean, JAMS built an entire facility up at 555 West 5th that looks like the ones that I see when I go to London for the LCIA. I mean, these are big facilities that can handle major arbitrations.
Well,
So I think it will grow.
It's been a treat to chat with you a little bit today and to follow what's been a very prominent and successful career that has now migrated into a completely different arena and with considerable accomplishment at that. So I want to thank you for taking the time to be with us to share a bit of your experience. And on behalf of our listening and viewing public, uh, the fact that you take some time to be with us today, I think is greatly appreciated.
That's fun. It was really interesting. And you asked me questions that I had to think, oh, why am I doing this? What are my motivations? But I think you see how I am motivated in the direction of I want these people to be good lawyers, good counsel, good arbitrators, and just good all around practitioners.
Well, keep up the good work. The world is a better place for what you're doing here, particularly the future of our specialty practice and arbitration, I think, is in better hands with the young people that you're helping to produce for the generations to come. And so, as I say, keep up the good work, David. And thanks again
Thanks.
for your time.